So first of all, I thank you very much to Raluca and the EMEA conference for inviting me. And I'm very sorry I was kind of on time, so thank you for that. It was a bit late to be fair. The reason is that I just flew in, so it wasn't my fault. It was the plane's fault, or the pilots. So what I'm gonna be discussing as a first topic is, let's say, what happens whenever you have an M&A transaction, and what are the issues from an antitrust perspective when it comes to disclosure of data, exchange of information, and so on. So this is, I think you already have, or you will have the slides, so I'm not gonna just repeat what's on the slides. It doesn't make any sense. You can just read them. What I'm going to try to do is to base it on my experience, hopefully on your experience as well, and then, if you have questions on something that I didn't touch upon, something that happened to you, something that you're interested in, you can just ask. So just to start, the idea here is just to say that whenever there is a transaction, exchange of information is a fundamental part. So you do need to exchange information, you do need to have access to information. So there is I don't think there is anybody, being it an authority, being it a lawyer, being it anybody, that thinks that you can actually have a transaction without exchanging information. And also it is very unlikely that you can have a transaction without exchanging competitively sensitive information. So the idea is that has to happen, that needs to happen. It is very important that it happens. It is important for the parties, but it is important also for the market. Because of course there is no interest by any competition authority to have suboptimal transactions. So transactions where the price of the target is much lower than its actual value, or vice versa, or transactions that end up in buying something or someone that you didn't want to buy, or that you didn't need, or that it won't lead to efficiency. So this is always to be kept in mind, because the idea is that if everything works well, so if you are exchanging information just for the purpose of the transaction, there is no competition issue. So it is justified by the transaction. So by the efficiencies, let's say, coming from the transaction. So this needs to be kept in mind, because otherwise, so if there was no transaction, then you would have issues exchanging the exact same type of information, even adopting the same safeguards and so on. So the transaction itself is the idea of a transaction, the existence of a transaction, and the need to exchange data is the justification to do something that otherwise you couldn't do. So the idea here is that the seller will want to actually give data. So the idea is that the data will go mainly in one direction. So if it goes also in the other direction, it's kind of a problem. So the seller will want to give data about the target, but shouldn't really get data about the buyer, with certain exceptions, of course. They may be interested in, for example, employment, what they plan on doing with their employees, and so on. So there may be exceptions, but most of the time the direction of the data is one. So it's from the seller that wants to get a fair price, or to show the performances and so on, to the buyer that wants to pay the right price, that wants to make sure that he's not liable for anything that he wasn't aware of, and to determine whether the transaction makes sense. So it's not just the value of the target. It's not that anybody will buy any target. They will buy the target that makes sense in their organization. So they also need to understand how to integrate it. I will spend more time on this slide, and then I will go faster, and just to give you an idea. For example, if you are a bidder, right, and you're just starting to bid, and you are a competitor, you will probably have access to less information than you would have access if you had already signed the agreement, because you don't need as many information during the bidding phase instead of the post-signing phase, because in the post-signing phase you will start also doing some integration planning, so thinking what's going to happen after you close. And if you are a competitor, what you could be doing, which is something that does happen, just participate to the bid, even if you're not interested in the target, just to get the information. So this is the reason why normally during a bidding, you don't have access to the same amount of information, and if you are a competitor, you have access to less information. So for example, if a PE fund participates to a bidding contest, and it doesn't have other companies that are active in the same market, it will be justified for it to have access to more information than somebody that is actually active in the market and is a competitor. So you can already see that it is very case specific. It is very specific to the companies involved. It's very specific to the transaction and so on. So what are the data? And then between signing and closing, you have several activities that we're going to discuss afterwards. But one of these is integration planning, which is the one where you need the most information. So you need the information. You kind of already need to know what the target is in its entirety, like how its business works, is customers, is suppliers. You will need pretty much all of this information in order to start thinking about integration. So you cannot integrate. You cannot actually, merge the two yet, because you are still going through the antitrust investigation and the antitrust review, but you can start thinking about it. And that is the most difficult moment, because you just have the two things that the transaction is going to happen, because they signed, so it is going to happen. In the worst case scenario, they're going to offer remedies, but we're going to get through this, and at the same time, you want to start doing something that you would otherwise have to do after closing, and therefore delay the integration, which means delaying efficiencies and so on. So you want to start as early as possible. And these are all the types of information that there may be issues, let's say, exchanging. I'm not going to go through them specifically, except for maybe thinking about the industries. So these are pretty much all of the strategic information that you may be exchanging. So all of the elements of competition between two companies. Of course, this changes based on the industry, right? So in some industries, there will be some things that are already disclosed to the public. So some prices may be already well known, maybe not be confidential. So you may not need to care about those. You can share them. In some other cases, you will have, for example, instead of prices, you can have fees, or in some cases, you can have the suppliers relationship being more important than the relationship with your customers in terms of competition. So if you think about, for example, a merger in the food and beverage industry, you will see that some information, for example, the price of the product to the consumers, being much less relevant than the price of the product to the supermarket, for example. Or if the transaction is between a supermarket and a company active in the food and beverage industry, then of course the supermarket will have its own prices, but they will want to know, and that is the reason why they shouldn't have access to it until the transaction completes, the price that the same product is sold to another supermarket, for example, because this is where they compete. So even in a vertical, let's say, transaction, this can be also an horizontal transaction. So of course, the supermarket itself may have products in competition with those of the food and beverage company. And in that case, of course, you also have an issue there. So you may have new products coming into the market that you don't want your competitor to know about. You may have a supplier relationship with someone producing the boxes, for example, or the raw material that you don't want to disclose, and you don't want the other company to have access to it. You don't want the prices, maybe you don't want the rebate system that you have with other supermarkets. Maybe the prices are not that complicated, maybe they are exactly the same, maybe everybody has the same list prices. So everybody has the list, but not everybody has the rebates. So it depends on each individual transaction. There will be, and each individual industry. So there will be industries where all of this is irrelevant, but what is the most relevant is R&D. So it's completely transparent, but what you care about is what's going to happen next. So you don't care about what's happening today because you know it. Maybe it's a very concentrated industry. You don't have that many competitors. This may be the case, for example, in telecommunication. So if you have a very concentrated market with just 2 or 3 players, the difference between these will not be the main element, let's say, of competition. The strategic information may not be the prices they are charging the customers, because that may be public, that's probably public. It may be the new offer, the one that they are developing and they want to launch, and they want to be the first ones to launch it, and there's some time to actually get the customers from the other one. So it depends a lot on the individual industry. It may be the plans to launch a new network, for example, a faster network. It may be the plan to actually buy antennas, for example. It may be the suppliers, the relationship with the suppliers of antennas. So it's all of this depends on the industry very much. But what's important is if you think about that data, if you don't want that data to be public, and you don't want, and even more, you don't want the data to be in the hands of your competitor, then it shouldn't be in the hands of your competitor just because you're buying it, or because this one is being bought, right? Or because you are being bought by this other one. So the idea is you are still competitors, you should still behave exactly the same way as you would behave otherwise, with the exception of the need to do this, for example, or to respond to the authorities' request, or to preserve the value of the target. So there are exceptions, but otherwise the relationship should stay competitive. So this is the legal framework. I'm just going to go through it very quickly, just saying that the reason why we are discussing this is that when you notify, and I'm taking the EU approach, of course. So when you're notifying a transaction, then you cannot close. You have to wait until the authority analyzes the transaction and says that the transaction is fine. So the reason why you cannot integrate, the reason why you cannot exchange information is that the authority needs first to actually review it. And the reason why you can't exchange information and the reason why you can close and so on is because of, let's say this kind of sums it up. So once the eggs are scrambled, you cannot unscramble them. So you have even a case, I mean, I'm going to discuss it later, where they specifically say once you have disclosed the information, you cannot take it back. The information is out there. Okay? The buyer got it. So in that specific case, which is Altis, so probably you already heard of it. There was a specific competition issue, and there was a divestment in an overlap. So if you disclose all of the information about this overlap, let's say about the business overlap in business, and then you divest it, you're divesting something that everybody knows everything about at the company that is divesting it. So if I am the buyer of this divestment business, I will know that I will never ever be able to compete with you, at least on the same terms, because you already know all my cards. So this is the reason why you have this standstill obligation. So you cannot close, and therefore you cannot exchange information. Now, what happens? So there is a very important reason why it makes sense for the authority to allow the exchange of information within these, let's say, specific objectives. And the reason is that pre-signing, of course, we already discussed it, so there is an interest in the market functioning well, including the acquisition market. But after signing, there is an interest in the transaction closing as quickly as possible and having as little, let's say, impact on each of the parties' business as possible. Why? Because once you're signed, then you get press release from both companies that always say, you know, we signed this agreement and we are undergoing, you know, the antitrust review. So the transaction will close on this date, subject to antitrust review, subject to clearance. This is the press release. It's almost always the case because normally lawyers look at it before it goes out. Issue is the press, for example, or the employees. So on the press, it will be A buys B. That's it. It won't say that there is an antitrust investigation. It will not say that it will take this long. It does not say that it could not happen, that the transaction could not happen. It's just A buys B. And then it explains what are the effects and the reasons for it and so on. So the market already thinks, oh, okay, so this happened. So these two companies are one now, right? And the employees, lots of them will think, oh, okay, so we are working for this other one now. So we're not competing with them anymore, or we're not negotiating at arm's length. We're not, when we are going to the supermarket to sell our product, we're not selling it to a third party. We don't need to actually get as much as we can from this third party. It is us. So we can just give it for less, or we can just ask, listen, we're going to give you this, and you can give us something else. We can give them any information they want, and so on. So there is a softening of competition between these two players. And this is even worsened by the fact that even if employees knew and they got the information, the communication, and the press is very thorough and specifically say it may happen, it may both be, let's wait for the antitrust authority to decide. Even if that happens, still your incentives change. So if you are the target, why would you risk pissing off your future employer? So you are discussing, you're negotiating, for example, if it's a vertical merger with someone, or you are competing with someone, right? And going for the same customer. Why would you step on his foot? Why would you do that? I mean, it's like today it's fine, and then tomorrow you are going to be under it. So you have very little incentive. You should still compete, but your incentives are much lower. At the same time, the seller has no incentive to invest whatsoever because he sold the business, except if there is a specific clause. Normally there are clauses in the SPA that says the business needs to be run as usual and so on. But there are a lot of things that can be debated whether they are as usual or not. So what happens is that the seller will decrease his investments. They will put much less money, will try to get as much money out as possible from the target. And then the buyer, of course, saw an opportunity in the transaction. So it should be able, it wants to integrate and to get these benefits as quickly as possible. So there is an interest to make sure that this phase is as short as possible, let's say. But of course, this does not really depend on the parties. And sometimes it doesn't really depend on the authority either, because there is time necessary to prepare the filing, there are questions, the analysis needs to be thorough, and so on. So what you want to do is to avoid that this time is actually a limbo during which nothing happens, the two parties are just separate as if nothing had happened, but with everybody having in mind that actually something has happened. So you want to make sure that this time is not completely wasted. And this is the reason why you can exchange information to do specific things. And the things are these ones, in theory. I mean, there may be others, but these are the normal ones. So the normal ones are, you need to make sure that the target and the transaction keeps its value. So you need to know, for example, let's say that the seller, for whatever reason, decides that doesn't want to invest at all, doesn't want to spend even money on maintaining the facilities. So, or even it doesn't send anybody for example, any sales representative to negotiate, because it doesn't care anymore. It doesn't want to spend the money. It doesn't want the sales representative to use the car and use some money for gas, right? So let's assume that the buyer would not know, because this is an internal information, right? This is an information that is confidential, let's say, right? And to a certain extent, the buyer should be able to know what's happening in the business that he has bought. So as long as it is limited to just maintaining the value, so like a minority investor will have information rights, will get some information, will get some updates, but it is not a controlling shareholder. It cannot keeps on asking information, any information he wants. It cannot keep on having meetings with the business and so on. So it is okay to get information, to ask for information, as long as it is limited to just maintaining the value of the transaction. This is one, and this is the exception. This is it's almost never mentioned, but I mean, a lot of time, the buyer needs the information just to respond to the authority's request. So the buyer notifies the transaction, the authority asks questions, the authority will ask questions about both the buyer and the target. The buyer does not have information about the target, so it needs to get this information. And sometimes this information needs to be available even to someone at the buyer, because the buyer will need to see it, and will need someone at the buyer will need to see it, and will need to determine what is the best strategy. So most of the times it can stop at the counsel level, but sometimes, or a lawyer's level, but sometimes the buyer wants to know what the lawyers are going to plead. And in that case, some people at the buyer will need to have access to this information for nothing more than responding to requests for information or preparing the file. Last one is prepare for integration. Is the most important one. Is the biggest one. The biggest source of issues, let's say. And the reason why there are issues is that if the employees consider themselves colleagues and consider the transaction as if it had already happened, the first thing they do is they speak to each other and say, okay, so what are we going to do? Are we going to launch this product? Are we going to launch this other product? Are we going to stop developing this and put all money on this other one? Are we going to merge our relationship with the suppliers? What are your suppliers? What are my suppliers? What prices are you charging this specific, for example, business customers? Or what are you, what are your, for example, partners? Let's say that you are a bank and you are trying to enter the online market. So the online banking market more and more and more. And this can be because you just are not present there. Maybe you don't have a very good online banking system, or because you actually want to start competing with banks that are maybe only online or mainly online. So they cut on costs, they can offer different services, they can offer better exchange fees and so on. So if you are doing it, but your competitor is not doing it, this is an advantage, right? This is a benefit. So once you have so you start discussing with the providers of these services, you start negotiating, you start having agreements, you start developing a commercial offer. All of this takes time, right? So if you have it and the other one doesn't, even once you launch it, then this other one will need to catch up, and it will take time, it will take money, and it may not even get to the same point that you are. So this information, it is key. It is key to know that you want to do that. It is key to know how you're going to do it. It is key to know who you are discussing with. So all of this is something that you would want to do immediately. You would want to discuss and say, oh, actually, I'm thinking about doing it. Are you thinking as well? Or do you have actually partnerships with someone? Or maybe the other party is more advanced on that thing, and you can say, okay, so can I use the same agreements for example, exchange fees, or the same agreements for exchange rates? So there are a lot of elements, let's say, of course, of overlap between competitors in particular, but also between vertically related companies in particular. And all of these can be discussed to a certain extent, but they cannot be implemented. So you can start thinking about what you could be doing, but you cannot do it. And there is another important thing, which is, and you need safeguard. So you cannot exchange information freely. It's not the buyer and the seller. It's certain people at the buyer, certain people at the target. So I'm going to go there in a second. Just wanted to mention this because a lot of times this is forgotten. So you have the signing, pre-signing, post-signing. So you have an agreement or you don't have an agreement. And then at a certain point you have an agreement and you have a clearance. So you can close. From an antitrust, let's say, merger regulation perspective, you can go ahead. You can close, you can become one company, you can integrate from a merger control perspective. But you are still two independent companies. The fact that you got an authorization doesn't mean that you need to go through with a transaction. So you are still in a situation where you can go through with it, but you are not yet there, right? So you are still independent. So before you integrate, before you become one company, you are two companies. It seems strange to put it this way, but it is that simple. Either you're two or you're one. So if you're one, no problem, you can do whatever you want within the one, right? If you are two, because you haven't integrated, you haven't transferred the control, you are still two, and you should behave as separate companies. And this is extremely important because sometimes you have several different filings. So even if you got authorization in Europe, maybe you are still waiting for authorization in Brazil. And in these cases, you can integrate somewhere and you cannot integrate somewhere else. But still you need to integrate. So first you close and then you can actually act as you control the outcome. So going to the safeguards. So this is extremely important from practical perspective. So what happens? We said that you couldn't normally exchange information. We're saying that at the same time you should exchange information. So these two kind of contradict each other. So in order to do that, first of all, you need a justification. So the justification is maintaining the value, is valuing the target, is planning integration. So you need the justification, and then you need a safeguard. So the safeguard makes sure that you are not damaging competition more than it is needed. That's it. So why would you? So if you exchange information between two business people, right? This is the best possible exchange of information because at that point the two are directly competing. They're active in the same market. They're active in the same industry. They're active in the same division. They know each other maybe already. They have the same expertise. So this is the best possible exchange of information because you're gonna get the best out of it. For sure, you can align. You don't need anybody else to provide information. You don't need anybody to fill anybody in because the two of them know everything. The issue is that, of course, if you exchange information with someone that is directly competing with you, then he will use this information. I mean, he cannot not use this information once he has it, while he is still competing with you. So if you tell this person, that is the person responsible for the development of the banking offer online, that you are actually developing a banking offer, that you're using this provider, that you're getting these fees and so on, the day after, this person will not just say, oh yeah, let's wait for the transaction to close and then start actually doing something. It will just start. It will start even more if he knows that the transaction may not go through. So the more he knows that you're not one company, the more he's going to use the information. And in any event, everybody will tell him, yeah, but you need to still compete. You need to keep on competing as hard as possible. So this is the normal, rational thing to do. And so we cannot assume, and we cannot even ask, people that are active in the business, that are competing with each other every day, that are going out to customers, to not use all of the information they have to actually get the customer, or get the supplier, or get the best rates. So because of that, these people cannot exchange information with each other. So the clean team works in a way with the identification of a specific number of people, normally a limited number of people, that are not involved in the business. So this, of course, creates issues because the person that is in the clean team doesn't really know the business that well. It may be someone that has been hired specifically for the transaction. It may be someone that is just, for example, normally is the legal counsel of a company. They just gets the information, knows the company a little bit, but is not actually going out and getting customers, let's say. So this is extremely important. So a lot of times the council needs to review it. And one of the issues in Altis, for example, was that in addition to having no clean team, is that the CFO was involved in the exchange of information. So at that point, it is exactly the same as if you were two companies. One company, sorry. So you have the CFO discussing, getting information, and going back to his people and ask, okay, can we do this? And give me the information that I need to give the other party and so on. So that is exactly what's going to happen once the transaction closes. But before the transaction closes, you are two competitors. So you can exchange information that you need, but only with the limited, for that purposes. And these purposes normally do not need the business person to be involved. So it is more complicated, it needs more iterations, it needs a lot of time. For example, the legal counsel of the company to go to the business people and say, I cannot tell you why I'm asking this information, I cannot tell you, and even the question itself cannot include the reason, for example, why you're asking this information, as long as it is not one of those indicated there directly. So it can be a sub-reason for it, and a lot of times, of course, the business person will have difficulties sharing this information because doesn't know what this information is going to be used for. So there are a lot of difficulties in doing it, but this is the only way to do it. I mean, you cannot have a business person in the clean team. So the clean team has to have clean hands and not touch the business because they will have confidential information. So they will get the information, the legal counsel, for example, of the company will get the information and he cannot use it. It cannot use it. It can only use it for these purposes that we discussed before, which normally start and end. So it's, I need to plan for integration, so I need this information. I will gather this information and will stay there. Because I cannot integrate. So I will just get the information, I will collect everything I need, I will organize it as long as I can, but it stays there. It doesn't go further, because the next step is going to the business people to integrate. It doesn't get that far. But at least you have the first step, which is already happening. So what happens normally is that one side says, I will need this information to integrate. Can you start gathering them? So the local council, the legal counsel will start asking business people, can you give me this? Can you prepare the information in this format? And so on, and then it stops there. Of course, it is different if you have a actually it's very similar if you have a request for information. So you get the request for information, you ask the other side, can you give me this information? You get the information, and then it stays within lawyer and legal counsel or the clean team. It doesn't get out of it. It just stays there and then goes to the authority. So there cannot be a breach, let's say, of the clean team. The information cannot go out of the clean team. The other element is the data room. So this is important during in particular during the due diligence. So pre-signing. So before signing, what you want to do is to have all of the data that is needed to evaluate the business in a data room. And then this data room will have its own rules, and only some people will have access to it. And this is different, of course, depending on the company. So you will have some companies that are, for example, not competitors and can have access to certain information. Some that are competitors that cannot have access to that specific folder. You have the legal counsel that may have access to more data than the business person that needs just to evaluate the business for that specific transaction. And in that case, it needs that specific information. And still, whenever the information is competitively sensitive, so one of the strategic data that we discussed before, most of the times what happens is that either legal counsel or the lawyer or both review the data and says, okay, this you need and this you don't. So you have for example, let's say a presentation. You have 50 pages, and the reason why you're providing this presentation is, let's say, the forecast. So you think that the market is going to go in one direction, and your company is going to go in that direction faster than the market. You're going to have certain results and so on. The presentation itself may have a lot of other information, including just, for example, analysis of the forecast. But this maybe is not needed. So what you do is you have to black out everything that is not absolutely necessary. So it's not just the piece of document, let's say the document is not the piece of information, it is the individual piece of information within a bigger, let's say, reel of information that is contained in the document, for example. So this is extremely important. It is very important that the council reviews the data, because sometimes there may be something that is necessary, something that is not. And if you think about the data, I don't know whether we have it here, but the data itself, in addition to being important, the topic of the data, let's say the subject of the data, it is also important the way in which the data is presented. So one thing is to present your pricing policy, one thing is to present your average prices, one thing is to present your prices to a specific customer, or the price or the cost you are paying, or the cost of a specific product, or your average cost. So the aggregation of the data is fundamental. It's completely different, because one thing is to tell the buyer, I am making, I don't know, 5% EBITDA. And one other thing is to say, on this specific contract, I am making 1 million euros. It is completely different, because when I discuss about my business in general, that is enough sometimes, or most of the times, to evaluate that business, because I'm buying the entire business. One other thing is if I'm discussing one specific relationship, for example, or one specific customer. In that case, I'm giving information that is probably much less useful to evaluate the business as a whole, but it is much more useful to compete on that customer, right? So the more individualized, the more specific, the more detailed, the more granular the information is, the worse it is. And of course, the same goes with age. So the older the data is, the less relevant it is to determine your conduct, and therefore to determine the conduct of the information.